Does an investigation by the State Environmental Quality Review Act have to explicitly consider the impact on climate change? To find out, you have to read Matter of Elizabeth Street Garden versus City of New York, but it's 30 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Elizabeth Street Garden versus City of New York, published by the New York Court of Appeals on June 18th of 2024. The citation for this case is 2024 New York Slip Opinion 03321. And the issue in this case is whether a State Environmental Quality Review Act determination requires specific assessment of the impact on climate change before coming up with an answer as to whether there's a significant adverse impact on the environment. I'll explain all that in a few moments. The background that's helpful to understand and appreciate the context of this case is that under New York NYCRR Part 617, this is a New York City rule, there has to be a state environmental quality review conducted of every single Type 1 and Type 2 modification, Type 1 or Type 2 application to change something going on with a park or an open space or a green space in New York City. And the intention in that statute, in that section, it says the intention by the legislature is that all agencies, this is the quote, conduct their affairs with an awareness that they are stewards of the air, water, land, and living resources, that they have an obligation to protect the environment for the use and enjoyment of this and all future generations. And the basic purpose of the SEQR, which they call SECRA, that's what people generally call it as SECRA, is to incorporate the consideration of environmental factors into existing planning, review, and decision-making processes at the earliest possible time. And essentially, the lead agency, whatever agency is conducting the investigation, has to determine whether there's a significant adverse impact. That's the language. Is this modification, is this change, is this building project going to result in a significant adverse impact on the environment? And the lead agency there's certain factors the agency has to consider. They're listed in the statute. They include a significant adverse change in air quality, ground quality, or surface water, creation of material conflicts within the community's current plans, impairment of the quality of historical, architectural, or aesthetic resources. There's a whole plethora of numbered factors, none of which specifically say climate change, importantly. And at the end of this investigation, they have to do one of two things. The agency, after preparing this, after conducting a hard look, what they have to do is actually do a hard look on whether it impacts these things. And if it does not, they issue what's called the negative declaration, which is a declaration that it will not result in a substantial adverse impact. Or they say it would theoretically cause a substantial adverse impact, and then they do a full environmental impact statement. Okay, that's the two scenarios after this investigation. If they conduct it and they say it's a negative declaration, it would not result in a substantial impact. Then, if it gets appealed, the court's role is just to give deference to the agency and ensure that they gave a hard look to the factors and not second guess them, but just make sure that they looked at and considered all the different factors. Okay. So what are the facts in this case? The facts are that Elizabeth Street Garden is a 1-acre community sculpture garden in Nolita, which is north of Little Italy. That's what Nolita stands for. It's located at Elizabeth Street between Prince and Spring. If you have a second after this video, take a look at the sculpture garden. It's actually quite beautiful. It's owned by the City of New York. It's leased on a month-to-month basis to a tenant. It's used as a green space, public sculpture garden area. But the city identified it as a possible place where they can build 123 senior affordable housing units. They conduct it's a Type 1 modification. So they do a secret investigation and they find that it would not result in a significant adverse impact on the environment. They issue a negative declaration. At that point, the people who don't like that appeal. They file an Article 78 challenge proceeding saying that the administrative agency didn't do what they were supposed to do, abuse their discretion. The Supreme Court, upon review, this is the procedural history, they voided the negative declaration and ordered a full environmental impact statement saying that they didn't do the right thing. That gets appealed to the appellate division, and they reverse the Supreme Court saying you did the wrong thing. And they send it up to the Court of Appeals. And here we have a 6-to-1 majority dissent split. 6-to-1. The 6 on the majority say, in this kind of a situation, in a type 1 application resulting in a negative declaration, our role is very limited. We are just supposed to make sure that they took the hard look, that's the term, and rationally determined that the project would not have a significant adverse impact on the environment. Here they do. They look at it and they say they did take a hard look. We're not supposed to second guess them. We're not supposed to be the judge of the actual EAS about whether there's a negative declaration or not. They did a hard look, and we're gonna support it. The one dissent here by Judge Rivera is very extensive, and I encourage environmentalists to read it. It's very interesting. It's very long, maybe 30 pages. Where Judge Rivera said this is an inadequate review. Why? Because they never look specifically into whether climate change, the impact on climate change. They say she says New York City has signed on to the Paris Accords and other agreements where climate change is supposed to be considered, and they didn't live up to that. But ultimately, the holding here, the majority holding 6-1 is they do not have to consider climate change specifically when determining whether to issue a negative declaration. The quote from the majority here is, the agency is not required to address every conceivable environmental impact. So that's the case of Elizabeth Street Garden versus City of New York. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.